Makes you sound really important. And be paid a commission. Okay, so even though the sale has already happened, how can you pre-approve a sale that's already happened? Well, the court will essentially do that, if it's fair. So that doesn't mean you're disqualified just because the offer came in before the seller filed BK. The offer can come in before or after. That's okay, as long as you word your application correctly to get nunc pro tunc. You have to use that language. The judge knows what it means. Retroactively might not work, because we don't really know what that means legally speaking. Nunc pro tunc are words of art. Okay, I vote 2. Same facts as above, except Ollie presents buyer's offer before Ollie goes to BK. What happens to the deal? Can Ollie's attorney process the motion to approve the sale without Barney getting a commission? It could happen. A, one of the answers is, yeah, Ollie's attorney can process the motion to approve the sale without Barney getting a commission. He just leaves off the application to hire the broker and approve the commission, but he wants the deal approved. That can happen. B, alternatively, Ollie's attorney can so attempt to deprive Barney of the commission, but Barney can file his own motion through his own attorney to be paid the commission on equitable grounds, for the bankruptcy court is a court of equity. How does that work? Analysis. Well, A is correct, and so is B. If Barney's attorney tried to get the sale approved without Barney being paid, Barney can file his own motion to be paid, and the bankruptcy court will order him paid from escrow on equitable grounds if Barney was the procuring cause of the sale. If Barney had an exclusive right to sell, but was not, however, the procuring cause of the sale, Barney has no equitable right to be paid because he didn't do enough to benefit the sale. It's got to be the procuring cause on this sale that's approved pre-bankruptcy filing. It's technical in the distinction, but it's very real here, and there's case authority on that, as I've cited. Okay. So, if the offer comes in, accepted before the bankruptcy filing, it's okay. And in order to be paid, if the attorney doesn't do his job right, then Barney can come in on his own and say it was the procuring cause and get paid. If he's not the procuring cause, the attorney doesn't do his job, it falls through the cracks and Barney doesn't get paid. Just having an exclusive right to sell and there's an ultimate sale doesn't cut it. All right. Rule 3, the disinterested professional. Under the law, the bankruptcy court will not approve the hiring of a professional, a broker, to represent the trustee or the debtor in possession unless the professional is disinterested. It doesn't mean uninterested. It's disinterested. It means he has no stake in the outcome other than to perform his duty as the broker. I vote 3. I'll show you how that works. Broker Barney's real estate salesperson for the sale, Marie, is married to Ollie, or is a creditor of Ollie's. Can Barney qualify to serve as broker? A, yes, if Barney swears to be honest. B, no, regardless of any swearing by Barney, one way or the other, to be honest or some 4-letter word, he doesn't get in it. Analysis, a disinterested person is someone other than an insider who has an interest materially adverse to the debtor, is a creditor, or within 2 years after BK was filed was a director, officer, or employee of the debtor. That's the definition in the code. So, if your office, if one of your salespeople handling this transaction is a little dirty, so to speak, you're not going to get paid, because the bankruptcy court looks down over the glasses and says, well, this broker is not disinterested. That happens. So you got to be clean on that. So the best that Barney could do in I vote 3 would be to refer the deal to another broker and perhaps receive a referral fee for doing so. Cooperating commission. How does that work? Number 4, getting paid a cooperating broker's commission in the BK sale. In order for the cooperating broker to receive a sales commission, the motion for sale should seek to have the cooperating broker and his commission pre-approved. Also, otherwise, the cooperating broker is not entitled to be paid a commission unless he or she brings an equitable motion, therefore, and is granted by the court. How's that going to work in hypothetical? All right, here's number 4. Cooperating broker Charlie, representing the buyer, Betty, asks Barney, that's you, if he, Charlie, will be paid a cooperating broker's commission from ESCO on the bankruptcy sale, to which Barney says, sure, you'll get it. What should Charlie do? Well, Charlie should A, assume that Barney's attorney will protect Charlie. B, fear that Barney's attorney may file a motion to approve the sale, but forget to seek to qualify Charlie to be paid a commission, broker's commission. C, what should Charlie do? Well, he could talk directly to Barney's attorney and insist by letter to him that the motion include his application to be approved and paid. Prepare a declaration that will support it. How's the analysis work? Well, A is wrong. In law, never assume anything. Get an agreement. B is correct. Such feared result may very well happen, intended by Barney's attorney or not. Things slip through the cracks sometimes. C is the best answer. To make it even better, Charlie may hire his own attorney to make sure that the motion is properly and completely filed with bankruptcy court, as opposed to having to make his own motion to have his cooperating broker commission approved. That's kind of messy and requires a second hearing. Summary. Do not fear bankruptcy sales. They can be profitable to you. The bankruptcy court will generally approve a total commission of 5, even 6% on home sales and more on raw land. But get your ducks in a row. Make sure that you protected your right to be paid the commission out of escrow. You don't want to be standing in line with other unsecured creditors of the seller debtor, who generally has no money, most of whom will never be paid anything. All right, addendum. We're just going to finish up on the addendum, and then I'll open it up for any questions anybody